If you suspect that the company is planning significant layoffs, you should be aware of your legal rights and protections under the Worker Adjustment and Retraining Notification Act. Consult with legal counsel or seek advice from relevant labor authorities if needed. The Worker Adjustment and Retraining Notification Act is a U.S. labor law that requires certain employers to provide advance notice to employees and government agencies in the event of significant layoffs, plant closings, or other employment loss events. Each state in the United States typically has its own website or department responsible for administering and providing information about the WARN Act and related employment and labor laws. These websites often serve as a resource for both employers and employees affected by WARN Act-related events. The specific name and website address of the agency or department responsible for WARN Act compliance may vary from state to state. These websites typically provide information about the WARN Act requirements, guidelines for employers on how to provide proper notice, and resources for employees who are facing layoffs or plant closures. These websites can also be a valuable source for accessing the necessary forms and guidance for compliance with the WARN Act. To find the WARN Act information for a specific state, you can perform a web search with the name of the state followed by WARN Act website or Worker Adjustment and Retraining Notification. This should lead you to the relevant state agency or department's website, where you can find detailed information and resources related to the WARN Act within that state. Under the Worker Adjustment and Retraining Notification Act in the United States, employers are required to provide notice to their employees, certain government entities, and in some cases labor unions when they plan to conduct a mass layoff, plant closure, or other employment loss events. The specific requirements for reporting a layoff to the state WARN agency include: 1. Size of the layoff. Generally, the WARN Act applies to employers with 100 or more employees. If an employer has fewer than 100 employees, WARN Act requirements may not apply. However, this threshold can vary by state, so it's important to check the state-specific regulations. Some states have their own mini-WARN laws that apply to smaller employers. 2. Number of affected employees. Employers must provide notice if the layoff or plant closure affects 50 or more employees at a single employment site. If the layoff affects fewer employees, WARN Act requirements may not apply. 3. Notice period. Employers must typically provide at least 60 days notice before the layoff or closure. If the layoff is due to unforeseeable business circumstances or a natural disaster, the notice period may be reduced or waived, but the employer still must provide as much notice as practicable. 4. Notice recipients. Employers must provide notice to affected employees, their representative, the state's dislocated worker unit, and the local chief elected official where the employment loss is occurring. 5. State WARN requirements. Some states have their own WARN acts that may have additional requirements or variations from the federal WARN Act. Employers need to be aware of and comply with both federal and state regulations. The exact requirements and definitions may vary by state, so it's important for employers to consult both federal and state-specific regulations to determine their responsibilities regarding reporting layoffs under the WARN Act. To ensure compliance, it's a good practice to consult with legal counsel or the state labor department or agency responsible for administering the WARN Act in the specific state where the layoffs are taking place.